Okay, so welcome to this Expert Voices seminar on improving court responses to violence against women and girls. My name is Phil Bowen. I'm Director of the Centre for Justice Innovation. The Centre is a not-for-profit organisation that seeks to build a justice system which every citizen believes is fair and effective. And in doing that, we deliver a range of work. To deliver that vision, so hands-on support to practitioners, conducting research into how things work as they currently are and how they could work better in the future, and we promote evidence-based policy reform. Now, obviously, this Expert Voices seminar sits at the heart of the approach that the Centre has, bringing together experts from both practice fields, research fields, and policy fields to discuss, debate prominent issues in our justice system. This Expert Voice seminar is one of a number of events that we've held over the past year. So we've held similar sessions on trauma-informed practice, justice and the spending review. Our latest one was on antisocial behaviour and respect orders. And coming up in April, we'll be hosting another Expert Voice event discussing the experience of women who come through the criminal court, which will be chaired by one of our associates and a member of the new Women's Justice Board, Katie Swain-Williams. Those are all available to watch on YouTube, and we'll put the link in the Q&A section for you if you're interested in any of those. But turning to today, so we're focused on violence against women and girls, and specifically on how courts can provide a better response to it. We'll be discussing different models of specialised court that exist both in this country but also internationally. And I'm delighted that we have a really excellent panel to discuss these issues with you. So we have, our first speaker will be Karen Senogles, Specialist Domestic Abuse Courts Mapping Lead and Criminal Justice Programme Manager at Standing Together. Karen and I have worked on this issue for a number of years, certainly over 10 years. I'm sure Karen goes back even further than that. And then also Andrea Campos-Vigouroux, Policy and Strategy Lead at the Angiolini Inquiry, and a researcher who's explored how countries like Australia and Canada and the US use specialist courts to respond specifically to domestic abuse. So we'll hear from each speaker in turn. I'll then ask some initial questions, but as I said, as the speakers talk, please feel free to pop any questions that you have in the Q&A function, which should appear at the tab at the top. So just to set the context, I just want to briefly cover kind of where we are in this kind of political moment. As you'll no doubt be aware, one of this government's missions is to create safer streets, and in particular to do that by halving violence against women and girls over the next decade. We understand that a new VAWG strategy will be published imminently in the spring, whatever that exactly means. And I was saying to Karen and Andrea, I was looking back at the last strategy published in 2021, which referred itself to the previous 2010 and 2016 and 2019 strategies. So we are full of strategies, but whatever the new strategy will say, the scale of the challenge is obviously pretty stark. Last year, 83 women were killed by their partner. Nearly 7% of all women and girls aged 16 or over have experienced domestic abuse in the last year. That equates to 1.5 million adults. It's clearly a big issue for policing. 15.8% of all offences recorded by the police are domestic abuse. 72% of those were those where victims were either women or girls. And some long-term research on the impact of violence against women and girls shows that women who are victims of rape or sexual assault, 63% of them reported mental health or emotional problems. 10% reported they tried to kill themselves as a result of that abuse. So in the face of all of this, obviously, improving the court response is never going to be the single solution to that problem, but it's clearly a very necessary and important part of it. People will be aware, and we can again share it in the Q&A. Just Domestic Abuse Commissioner did a recent report called Shifting the Scales about transforming the criminal justice system's response to domestic abuse, in which she called for, in particular, the re-establishment of specialist domestic abuse courts, which I'm sure Karen and Andrea will talk about. We've also heard, again, from this government that they were going to fast-track rape cases. Some reports in the press a couple of months ago saying that those plans are on ice until Sir Brian Levison's court review makes its recommendations, which again should be, in the civil service jargon, in late spring. So we await to hear what that is. So I think it's a really interesting point in time to be considering violence against women and girls, and that's why we thought it would be timely to discuss how practitioners, policymakers, and others can work together to improve the court response to violence against women and girls. So I will hand over to the panel now, starting with Karen for their reflection. So over to you, Karen.
Thanks, Phil. Hi, everyone. As Phil says, I've been doing this for quite a while, but I've worked in the criminal justice system for a very long time. Firstly, as a probation officer, and then more recently responsible for the establishment and embedding of specialist domestic abuse courts. I work for an organisation called Standing Together Against Domestic Abuse. It's a second-tier organisation which promotes the coordinated community response to domestic abuse. We also work in health, housing, MARAC, domestic homicide reviews, and basically anything related to domestic abuse. Being a second-tier organisation means that we do not work directly with victim survivors or perpetrators of domestic abuse, but we work with the agencies that do. We believe that the most effective way to protect victims and children, hold abusers to account, and ultimately prevent domestic abuse is the coordinated community response, or CCR as we call it. In short, the CCR recognises that multiple sectors and agencies have a responsibility and remit to respond to DA. However, no one agency can do it effectively by themselves. It requires agencies to coordinate their efforts, work in partnership with each other through information sharing and joint action plans. Unified efforts are underpinned by protocols, training, data, and so on, so practitioners can work together internally and externally in a coordinated way. So our team works locally and operationally with police, CPS, courts, probation, and IDVA service to ensure the DA courts that we coordinate operate as safely and as effectively as possible. We also work nationally and strategically to promote the specialist DA court partnership approach to DA within the criminal justice system. More recently, we completed the Mental Court project, looking at how domestic abuse is dealt with in the criminal justice system, which took us all over the country, and we've been working to assist other areas to start, reinvigorate, develop their domestic abuse court partnerships. But before we look at the findings of that project, I'll tell you a little bit more about specialist courts, or SDACs, as we call them. So why do we need them? It's not easy to escape the fact that the criminal justice system struggles to respond to domestic abuse effectively. The system doesn't work particularly well all round, least of all for victims of domestic abuse. Case going through the criminal justice system has to pass through a number of agencies. So it starts with the police, the CPS, courts, probation. These agencies have their own distinct remits, priorities and targets, and they don't always complement each other. All agencies are stretched and underfunded, so their capacity to respond to domestic abuse cases is challenging. They are complex cases. There's a lot of risk involved, as we know. And as Phil's recently said, we know that 1 woman every 5 days is killed by a partner or former partner, and it's estimated that 3 women per week die by suicide as a result of domestic abuse. There are multiple barriers for victims in domestic abuse cases to support prosecutions and take part in court proceedings. Victim survivors are usually not having to navigate the criminal justice system, but other aspects of their lives at the same time as a result of the abuse they're experiencing. SDACs were created to try and make that journey how a case goes through the system more centred around the needs of the victim. The focus is on improving the victim's experience of the criminal justice system by looking at what is needed to make that process safe, hold perpetrators accountable for the abuse, and provide an opportunity for them to change. So in 2006, the National Specialist Domestic Violence Court Steering Group produced an accreditation system to support local partnerships and achieving and monitoring SDACs in their areas. And this was based on the model that was then at Hammersmith, which has now moved over. So Hammersmith Court moved over to Westminster, and 2 SDACs operate out of Westminster. The accreditation system made explicit reference to the fact that although the SDAC has court processes at its heart, it's related to a broader whole system and within a CCR structure. Despite the widespread adoption of the model in the early 2000s, SDACs have suffered closures and deterioration over the past 12 years. This is likely because many magistrates' courts were closed during this period of time. So in 2010, there were 321 magistrates' courts open across England and Wales, of which around 145 were accredited as SDACs. By 2022, there were 156 magistrates' courts open across England and Wales. So between 2010 and 2022, over half of those courts had closed. Today, we estimate that fewer than 60 SDACs operate in England and Wales. Not all of these will be a true SDAC, working to the components that have been designed to make it work in the best possible way. And some of those are just in name only. So in brief, the objectives of an SDAC are to make the process as safe as possible for victims and children so that victims can feel confident to support the prosecution process, but also to be protected by the criminal justice system. Convictions are not a key target of the court, but convictions lead to sentencing, and this is key to holding perpetrators to account. Using the CCR, the SDAC achieves its main objective of victim safety, and the focus is to enable a coordinated response from criminal justice agencies and specialist services, as well as agencies from other sectors. Not everything that's essential to a SDAC happens on the day, as the partnership works outside of the hearing day to make sure information is available to the court. Criminal justice advocates advocate for victims and their wishes and feedback information and results in real time. Their role is crucial to the engagement of victims, and their independence is key. Data indicates there's a higher conviction rate for victims who have the support of an IDVA. We also have a court coordinator who liaises with all agencies, ensures information sharing and identifies gaps and concerns, and facilitates problem solving. An independent coordinator ensures that all agencies have an equal voice in the SDAC, which is an oversight steering group consisting of police, CPS, judiciary, HMCTS, probation, witness care and specialist services. The coordinator ensures that information is shared with local delivery groups and VAWG strategic partnerships, and they're also members of various pan-London and national groups. So I did mention the Mentor Court project. So this was funded by the Tampon Hacks to develop Westminster SDAC as an example of good practice and as a resource to enable agencies and partnerships from across the country and internationally. We've had a group from Bermuda looking to set up a court over there, wanting to use expertise and knowledge. So it enables them to visit, observe and learn from the experience and knowledge of agencies operating what's considered to be a gold standard SDAC. So as part of that Mentor Court project, and having identified there were inconsistencies in the way that DA was dealt with in the criminal justice system, we undertook a mapping exercise, reaching out to areas to find out what was available in their area, whether they had an SDAC, if not, how did they deal with their DA cases in the criminal justice system. We spoke to a variety of stakeholders, so it was police and crime commissioners, VAWG coordinators, police, DA services, probation officers, and we managed to speak to a couple of HMCTS staff. Unfortunately, contact with this group was limited, and it probably made the project a little more difficult than it should have been. But from this, we made a database of courts. We were able to visit 73 courts in operation, made detailed observation notes, and with the information from stakeholders, analysed overall themes. And whilst the report, which is available on our website, details the wider findings, I can highlight some of the elements that we identified. So we looked at partnership working frameworks, with most areas reporting strategic and operational partnerships in place, although membership and agency engagement levels varied greatly, as opposed to being embedded within core agency structures. Several areas had good information sharing and general communication among partner agencies, and some enhance this by co-location, which keeps communication channels open outside formal operational meetings. Some stakeholders question, however, whether good communication on the front line may hamper the effectiveness of an operational group. And we refer to this as the paradox of individual engagement versus institutional apathy. So therefore, issues being addressed dynamically and informally among partner agencies, largely thanks to the drive of individuals, may lead to less emphasis on a formal discussion forum where issues can be raised, and ultimately less commitment by senior management and strategic leads to embedding good practice. Therefore, partnerships working may not be sustained or sustainable in the long run. There were not always clearly defined pathways, for example, around data sharing among partner agencies due to lack of multi-agency protocols. And partnership working at times suffered from unequal relationships and lack of genuine collaboration, with statutory agencies failing to consult with partner agencies such as IDVAs. In some areas, steering or operational groups have been subsumed under general local justice area meetings, which have a much wider remit, therefore diluting the focus on domestic abuse, with issues not fully addressed in those fora. We observed a general inconsistency around key information available or required to deal with domestic abuse cases effectively in SDACs and non-SDACs, such as call-out history and victims' wishes with regard to restraining orders. It was unclear how thoroughly the information had been gathered beforehand, and in some courts we observed a reliance on key information being obtained on the day by an IDVA, if indeed there was an IDVA available. Bail conditions and protective orders are two of the most common measures of risk management and safeguarding of vulnerable victims in domestic abuse cases. We observed a number of unsafe practices relating to bail conditions and protective orders. There was little evidence of robust address checks when considering bail, and there were a significant number of cases arriving at court on a postal requisition without any bail conditions imposed on the defendant. There appeared to be an assumption in these cases that courts should automatically impose unconditional bail due to the absence of prior police bail. Now, that wasn't always because police didn't consider the case didn't warrant bail conditions, but because the time taken to complete the investigation meant that they couldn't use bail conditions. We observed a number of cases where the court didn't impose conditional bail because of an existing protective order, such as a non-molestation order or a restraining order, despite the fact that the defendant had been precisely charged with breaching that order. There was an inconsistency around restraining orders in terms of length, conditions, information required to support applications. And this is where the SDAC at Westminster comes into its own, where issues have been identified and a clear process established to ensure accurate information and safe decision-making. And as I've said, some courts have IDVAs, some courts don't. Dedicated IDVA provision is crucial to an SDAC, and our mapping exercise found considerable variation compounded by familiar concerns around resource constraints and short-term funding. There was a high level of reliance on the IDVAs by prosecutors for attaining information. At times, they were asked to seek and share information on the day with the court in session. This indicates that victims are having to make decisions with little or no time to consider what's best for them, even if it's possible to contact them at short notice. Quite often, there would be no IDVA available, and prosecutors were having to step out of court while the hearing was in session, making hurried phone calls and expecting victims to make immediate decisions. And also, there was not always a clear understanding by some agencies about the role and value of the IDVAs, viewing them as a source of information rather than a service for victims and survivors. We observed a good level of general knowledge by court staff, including reception and list calling teams, about the existence of an SDAC, but that did vary. Most prosecutors and legal advisors observed in court demonstrated a good understanding of relevant law and guidelines, and probation officers were generally well integrated into SDACs. Our stakeholder interviews confirmed that in some areas there were dedicated staff were deployed in the SDAC, such as prosecutors. However, stakeholders reported ongoing challenges to improving and sustaining domestic abuse awareness, especially among the judiciary due to lack of time or avenues afforded to train them. High turnover of staff, especially in the police, affected their knowledge and experience of local support pathways or structures, causing inconsistency among victims' experiences of services. The level of specific knowledge of domestic abuse dynamics among prosecutors, legal advisors and the judiciary varied greatly. As I said previously, while most showed an understanding of relevant law and guidelines, this did not always go hand in hand with an understanding of the nuances of domestic abuse and did not always translate into risk assessment and management. So, unfortunately, the consistent theme of our findings was the lack of consistency. Focus on victim safety is key to SDACs and their ability to deliver justice safely and in the long term. However, this wasn't always evident in practice. The efficiency of a court did not always correlate to victim safety or focus. Domestic abuse as a priority is easily undermined when courts are trying to manage caseloads. In some courts, despite stating that they cluster the DA cases, other issues take priority. For example, custody cases go into a different courtroom. Case management goes into a different courtroom. Sentencing goes into a different courtroom. At Westminster, all DAs dealt with in the SDAC regardless of the status of the hearing. Also, low caseloads have had a negative impact. We all know that there's a rise in reporting, but a drop in actual charging and then cases going to court. And therefore, the lower caseload seems to lead to less prioritisation. Single agency changes have wide-ranging impact on the process with a lack of buy-in at agency leadership level. However, not all doom and gloom. There are pockets of committed individuals of keeping good practice going. And interestingly, there's an appetite for SDAC. So when we were talking to stakeholders, where there has been an SDAC in the past, which has disappeared, people become reinvigorated. Where there's never been an SDAC, but then we tell them what they're all about, people become excited about the possibility of having one. SDACs are a model that works. It's fallen off the radar because it's not the shiny new thing. But if you want to keep victims engaged in the criminal justice system and safe while going through it, as I've said, it's a model that works. And Andrea is going to speak now, and she can give you some examples and information about what people are doing around the rest of the world from her research.
Thanks, Karen. Over to you, Andrea.
Thank you, Karen, and thank you to Phil for inviting me to speak about my research. So, as Phil mentioned, I'm Andrea Campos-Vigouroux. I am currently the Policy and Strategy Lead to the Angiolini Inquiry, focusing on police misconduct and standards. However, I just want to be really clear that I'm speaking to you today on my own behalf, just focusing specifically on this research, and what I'm putting across and the opinions I'm putting forward are entirely my own and don't reflect the views of the inquiry or indeed the chairs of the inquiry. So as Karen mentioned, I have been doing a lot of research on how these models of specialist courts have been adopted and used overseas and adapted. So the specialist court model was initially designed in the US, and they've been using them for some of the longest standing jurisdictions. So since the early 1990s, they've been going and running and been looked at as a way of focusing on how to respond to domestic abuse in the criminal justice system. I think there's a chronic problem in that, and this is internationally, in the fact that the way in which the criminal justice system responds to domestic abuse categorically isn't working. And there are some themes that just recur internationally in terms of some of the challenges. So lack of victim engagement, high attrition rates, the fact that agencies weren't speaking to each other, and as a result of that, it was resulting in poor outcomes in terms of convictions, but also that sense of procedural justice that victims are getting. Whilst we've seen some things improve, and indeed we've seen reporting improve and people being more willing to come forward, we're not really seeing a correlation and translation into a rise in prosecutions and convictions, and the growth in that area is still really sluggish, and the victim satisfaction hasn't improved either. And I think when people have an idea that the system doesn't work or is going to be traumatic or difficult to navigate, that puts them off engaging, and they seek other avenues or recourse to move on with their lives. And it means that perpetrators are able to offend again or don't have the accountability that they're meant to. So bearing in mind some of the work that was conducted by Karen, and I was formerly at the Domestic Abuse Commissioner's Office, working in this area as well, I wanted to look forward and see what was working internationally, what we could bring back here, and see if we could build some recommendations or look at rejigging the court model in a way that we could make it more holistic and see if we could adopt those practices. So I was awarded a Churchill Fellowship, where I was able to go to Australia, the US and Canada to try and understand how these courts were established, how they operate on a day-to-day basis, and speaking to key stakeholders involved in the running of the courts, and then hoping to use those learnings to design a specialist court model which could be piloted in England and Wales with consideration to the existing court models. And as Karen said, just the recognition that there is a lot of inconsistency in practice. And I think what we want to do is make sure that rather than there being a patchwork of provision or a postcode lottery, that there is like one good consistent model that a lot of areas can adopt. So victims know that regardless of where they are, they're going to get a good response from the criminal justice system. So as part of that work, I spent in total about 8 weeks traveling around. So I went to Chicago, Toronto, New York, New Orleans, Brisbane, Southport, Melbourne, and I also spoke to people virtually in Canberra, in Australia, and Sydney, while I was taking advantage of the fact that I was in the same time zone. And during that time, I visited a range of courts. So looked at specialist courts which were just criminal justice focused. There were some specialist courts which were just compliance courts. So where a perpetrator was given an order, they would then they would just look at how the perpetrator was following that order, whether there were any breaches, and also if they had been told they had to go on a perpetrator program or a drug and alcohol program, how they were responding to that. And that was a more holistic model. I also went to observe integrated family violence courts, so where judges undertake both the family court proceedings where they existed and the criminal justice proceedings all in one, so to avoid, again, victims and perpetrators having to essentially go through this, similar types of proceedings and submit the same kind of evidence, and actually be quite re-traumatizing for the victim to constantly recount and be cross-examined on their version of events, as well as looking at some wider models and more therapeutic court models, which were more holistic. And I'll just give you a whistle-stop tour into some of the best practice aspects that I saw internationally, and refer to the specific court where I saw them. So as Karen mentioned at the beginning of her presentation, the coordinated community response is seen as being, one of the best practice way of dealing with domestic abuse, and that's on the basis that it means that agencies are talking. When agencies are talking, intelligence is being shared so they can catch perpetrators early, but also they can make sure that victims don't get lost in the system. Also, if you look at the strategies that are coming out, and I completely echo that view of there might be some sort of strategy fatigue, but also strategies that are being published by organisations like policing, they in their own ways to respond to domestic abuse and in their VAWG strategies say, this isn't just something that policing can do on its own, and that's completely appreciated. And I completely echo that. It's something which has to be done as a part of a coordinated response, because victims don't just look for a criminal justice response, but it's the response that's going to keep them safest, and that's something which we do have to really recognise. But the courts that were really working well in areas across the world were the ones that had a really strong coordinated community response. So in Southport in Australia, there was already a strong coordinated community response within that community, and that was actually led by an amazing domestic abuse service there, who already had a coordinated community response and made sure that services were talking to each other. And so when the specialist court in Southport was established, it essentially ended up being the cherry on top of the cake. And so through that work, the domestic abuse service was able to then refer victims to the specialist court, and then they pushed for a post of a court coordinator, who, as Karen said, is really, really crucial to this. So in Southport, they had a very brilliant court coordinator who'd be in charge of bringing all the services together around a table. They would look at the cases that they'd seen the week before. They would look at any snags in the court listing problems. They would address those, and they would sort of discuss how they were going to bring them forward. But then also through having a court coordinator, it meant that, say, where services weren't talking to each other, he could sort of pull them up on it, but also, bring them together in an informal channel. But again, it was that constant theme of having someone driving this work forward. And through doing that, it also meant that if there was any change in staff or the representative from an agency, the court coordinator could come, bring them in, explain what the court was there to do, and make sure that everyone within that court organisation was able to remain engaged and focused. And I think one of the biggest issues, and I think Karen mentioned, is that essentially if there is any sort of turnover within a system, then it's so much of it is actually driven by the individuals who are part of that. If there's any form of turnover and the new person isn't engaged with immediately, they can just decide to disengage, and there's no real requirement on them to do that. And so that's why individuals like the court coordinator are so important to the function of this, and it creates that sustainability piece, and it makes sure that there's that longevity aspect. So rather than having to fight for constant new buy-in. The other best practice element of a specialist court that I saw was the fact that spaces were designed to be safe. And I think, safe by design is a really important aspect of a specialist court model. And this is I fully recognise that this is probably one of the bigger issues in terms of actually asking for infrastructure funding. The courts here are very old. We've had loads of them shut down. We're not really doing very well for court space. And I think as a result of that, we've forgotten some of the principles of safety that need to be surrounded in courts. And I think we see it in all types of crime, but it's more important in terms of domestic abuse just because of how traumatic it can be for victims to attend and give evidence and engage in the system. What we saw in places like Melbourne and in the Southport Court was that essentially when you entered the court, there was a specialist entrance for victims, and they could go straight into a special victims waiting area. And within that waiting area, there were specialist domestic abuse advocates who they could talk to and seek advice on the specialist court on the court process, whether that be securing a non-molestation order, or whether that was actually them wanting to assistance to make a criminal justice report to the court. And it meant that there was also corridors leading directly from that space, which was just for victims, directly into the courtroom. And so it meant that they didn't have to worry about potentially bumping into the perpetrator, and being caught short or being waiting rooms with the perpetrator, and gives that extra element of safety. And I think what was also very good and I saw this in Australia, but also in some of the New York courts, was that in terms of that safety by design, there were also creches built into the court, and they were run by domestic abuse organisations. And so when victims were going to court, they didn't have to worry about having to leave or what would happen to their children if they couldn't bring their children in, or they had very young children. And they had volunteers there, so they could drop their child off at the creche within the court, and then there were people there that would just support the children, and they could either sort of do mini lessons, and they had tutors in there, or they had essentially like nannies, or in the US they were called volunteer grandparents, who would sit in the rooms with the children and spend time with them. And I think it reassured the parents that they weren't having their toddlers in the back of the courtroom and traumatizing them in that way. And I think it's those holistic aspects again that make people feel a lot more comfortable, and also just make them feel more comfortable in staying engaged in that process. The next aspect that I saw, and I sort of touched on this briefly, is the availability of domestic abuse services and the co-location. But the co-location models in the places where I think it worked best was where you essentially had all of the different services that victims and perpetrators as well had to navigate were in the one courthouse. And as Karen said earlier, these cases are very complex even for the agencies working in them, let alone the victims and survivors who are navigating them and having to navigate multiple systems. So particularly if they are just coming around to a reporting for the first time, or when this is the first time navigating the criminal justice system, it's terrifying, and they can be in a state of trauma and chaos. And I think that the fact that they will then have to navigate housing systems, as they're usually the ones who have to flee, that they're trying to find support for their children, they might have to move them schools, and also trying to navigate how you get legal advice. All of that is very difficult for most, for anyone, let alone someone who has never navigated systems before. And the co-location model is an ability for essentially victims to have a one-stop shop. And that's not very common in England and Wales. And when you look at the Domestic Abuse Commissioner's mapping of domestic abuse services, you see that actually even the way that services are provided can be quite disjointed. And so it requires multiple referrals for different things, but having everything located, your domestic abuse services, perpetrator interventions, children's services, social services, all in the courthouse, it meant that essentially victims could just come in and talk to people. In other places like New Orleans, where they were trying to set up a specialist court, they had a family justice centre just opposite the courthouse. And so while the courthouse itself wasn't set up for the domestic abuse system just yet, they could say to the victim, go to the family justice centre, which is just across the road. And that also is sort of like a one-stop shop model where all your services are available under one roof. And that again reduces that systemic trauma. And on the flip side, if you're looking at perpetrators, it also meant that when perpetrators were told you need to sign up to a drug and alcohol program, or you need to sign up to a perpetrator program, they would be pointed as to the exact room that they needed to go to, and they were saying, you know, Mr. Smith, go downstairs, first floor, second cabin, put your name down, sign up to a program. And then that would mean that they also didn't have the excuse of saying, oh, I don't know how to do that, I couldn't sign up, because they could just do it there and then. And it builds that instant accountability, and also it's just quite cognizant of the fact that if the perpetrator has you know, complex needs, that means that they could engage with them early, and at an easier stage. The courts essentially were very judicially led initiatives, and that's very important. I think it's one of the things that we have to consider when we're trying to push for them here. It's the fact that it's judges tend to listen to other judges, and they have the most clout within that space. And I think that's something which we have to be really conscious of. And you know, the models that I saw were always driven by very exceptional judges who, by hook and by crook, were trying to make cases work. And in certain cases where they felt like their colleagues might not be dealing with cases, they would say, why don't you just transfer that case to me? And they would sort of have strong lists. They would have, you know, a preference for listing days, and they would say, oh, actually, I'm going to take this case on. And that again showed, I mean, through having that, it meant that the process was coming together a lot more cohesively. And on the flip side of that, it means that also if you have judges who aren't as engaged, it can be really problematic. And we saw that in certain parts of, so in Southport, just due to trying to avoid judicial fatigue, and just the vicarious trauma of the role, they rotated the judges every 3 months, and then, you know, they'd have the judge come back probably like a year later on rotation, and that sort of caused some problems because it meant that they would have to be retrained on domestic abuse if they hadn't sort of, and also how that court functioned if it hadn't worked before. And so there is a piece there around making sure that actually if something is judicially led, you're integrating that knowledge across the judiciary to make sure that it's not lost, and having that institutional guidance as well. The domestic abuse courts are very much accountability courts, or the ones I saw were. So rather than traditional problem solving courts. So the best practice models offered interventions and diversions for perpetrators, as sort of saying, you know, sign up for a drug and alcohol program, to go to a perpetrator program, really acknowledging that actually there had to be a behavioural change from the perpetrator. And there was an accountability aspect in that, in a lot of the areas where I saw was, you know, sitting in the compliance docket where you had people coming back after 3 months and people saying, how have you been doing? And the court coordinator would stand and read out the report that had been sent by the service and sort of give feedback to the judge, as well as the individual being able to feedback to the judge how they'd been engaging with it. And similarly, in Australia, you had judges who were saying, you know, oh, you're quite young, this is a sort of medium risk case, so you should go to this kind of program, but also being able to refer individuals who were Aboriginal or Torres Strait Islanders to programs which had been specifically designed for them. And that was in the knowledge that, you know, they wanted it to be quite holistic, but they were also saying to the perpetrator, what you've done is really bad, and is, essentially telling them and that there was going to be that accountability for their actions. But where there was a lack of compliance, they were told, we're going to bring you straight back into custody as a result of that, or they would charge them with something more serious and for the breach of the order. And during that time as well, there would be safety measures in place. So non-molestation orders would be put in place, or drug and alcohol monitoring, as well as sort of exclusion zones. So it wasn't just okay, go to a program, good luck. It was very much always surrounded by different conditions to make sure that they weren't being breached, and there was a lot of victim safety in place, and asking victims what they wanted as part of that. And all of that was underpinned by really strong therapeutic jurisprudence. So judges centered decisions around the safety of the victims and making sure that the interventions that they were offering weren't also going to put the victims at risk. And there was always, that sense of making sure that there was that compliance. And again, that coordination piece is really important, because when the court coordinator brought all the services around the table, they could say, you know, the individuals from the perpetrator program could say to the police, we've not seen Mr. Jones for a couple of weeks, so we might want to go and check up there. And so rather than the police having to sort of immediately go and arrest somebody, they could just go round and be like, okay, we've had it, just to let you know, we know that you've not been attending. Unless you go and attend, we're gonna have to arrest you. And then you'd sort of again see that re-engagement, or they'd check in and be like, why haven't you been engaging? And if it turned out that, you know, they had a drug and alcohol problem or something different that they hadn't been addressed, then they could come back and say, actually, he's not ready to engage, we think you should do this instead. And then the judge could vary the order very quickly. And so it just meant that the system was working better, and it was working at a much faster pace. In terms of the functioning aspects of the court and the individuals involved, the best practices there were around accountability frameworks. So regular meetings were attended by all the stakeholders to discuss issues which had arisen on a given day and how to prevent them from arising, as well as having a forum to raise general concerns. All agencies and employees working on the court floor had specialist domestic abuse training. So from the registrars at the counters to the judges, and that trauma-informed approach of making sure that they could advise people properly and understood how to advise people in distress. And also, yeah, the coordination aspect. So having a funded court coordinator to bring everyone together and ensure that everything was running smoothly, who was able to make changes to the list based on people turning up and not turning up. And that's not to say that everything was functioning perfectly in all the courts, and I think there were snags in a lot of areas, as there would be, but it did. And I think particularly if I had to pick a golden example, the Southport Court was a really good example of how that model is functioning, and was honestly really inspirational. And that was being also tested, a very similar approach being tested in Melbourne. And they, again, I think, because they are newer, and Australia is really trying to respond to domestic abuse because they've got a huge problem with domestic homicide. You can see that there's a real galvanization of the criminal justice system in trying to respond to this area. And so the way in which they're approaching things is quite innovative, and I think there's quite a lot of spirit between the organisations to make sure this works. What I will say is that the government in Australia has put proportionally quite a lot of funding into this model, and we have to recognise that that's a big challenge that we're facing here at the moment. The fact that, you know, it's really difficult to get funding for this model, but the thing is that essentially it's going to save the criminal justice system a lot of time and money in the long run, and not just the criminal justice system, I think wider services. So it's definitely worth the investment.
Great, thank you. Two wonderful presentations, and lots of questions coming in the Q&A, which I will go through. And please do keep on sending questions in that my colleague Miranda will curate and publish, so everyone can see that. We'll try and get through as many as possible. Just picking up a bit on I think you sort of both mentioned it, this issue of sort of judge-led, the judge-led dynamics internationally, with specialist courts, and judges do listen to other judges. Is that something in your experience, Karen, and in your experience, Andrea, that do we have judges in those kind of leadership positions who are pushing for greater specialisation in England, Wales, or is that an element that's lacking at the moment? Anyone want to comment on that?
I'm quite happy to comment on that. I would say no, it is an element that's lacking. Whilst we have so Westminster Magistrates Court is it's the Magistrates Court, so the majority of the work is magistrates. But we do have a district judge who sits on our steering group. However, she's unable to attend most of the sessions because of lack of time available to her. And I would say for us, we're lucky that our two magistrate representatives are, you know, they're engaged in it all. They're really keen to work on it. But I would say that that's probably not the case around the country. And I think, as I said in my presentation, we try to engage HMCTS and because that's the only way you can get to the judiciary as well. And that was very difficult for us. And I think there's probably judges out there who are keen to be participating in it, but just don't because they haven't got the time or the contacts to be able to do that.
Interesting. Yeah, no, I think it's a sort of, I mean, it's one of the things, so it's one of the things the centre does as part of our work is we're the kind of national champion for a model in the family courts called Family Drug and Alcohol Courts. And in that arena, there are, I'm going to get my facts and figures wrong, 13 SDAC teams servicing 24 courts, blah, blah, blah. We've always had a very engaged president of the family division who's, successive presidents have been very engaged with SDAC. And there's been just a growing group of judges who've sat and presided in family drug and alcohol courts who love it and want to see more of it happening. And that's never felt quite the same with specialist domestic abuse courts in my experience. And that clearly, if it's something that we want to see in the future, that's clearly an element. I'm going to go to questions just because I'm talking when I really shouldn't. So I'm going to go to the first question that Emily asked 30 minutes ago, which is about DAPOs. So do you think there's effective agency work and communication between the police and courts when issuing domestic abuse protection notices and orders? What could be done better to protect victims and survivors when issuing these orders? So just for those people who know, DAPO pilot started when? Sort of in November, is that about right?
Yeah.
Anyone want to comment? Either of you want to comment on that element of our framework?
So from what I've heard, the issuing of DAPOs in the areas that's gone out has been quite good, and then also where there have been breaches, the police have been quite good at charging people post breach. I think the hard thing is actually understanding some of the requirements of DAPOs. So like DAPOs are able to give people positive requirements, so that can be going to attend a program. That aspect they have not really been any preliminary findings, and I think actually it's really hard to do that when there's a backlog of issues within a backlog of services in a local area. I think that this is where a specialist court model would actually be really good, because it would be able to bring all those together, and the DAPO requires a judge to be able to issue those. So I think whether there is multi-agency, I mean, the way that the DAPO pilot is being structured, they are trying to bring lots of agencies together in order to be able to do this work, but whether or not it's actually being effective, I think we're yet to see it. But it's in terms of the charging, where there is a breach of an order, we have seen some real action being taken. So hopefully we'll see some positive results.
I think also the numbers are limited at the moment because quite often, because it's just pilot areas, if you don't live in that pilot area, then you may have committed an offence, or your court hearing may be in that pilot area. But if you live outside that pilot area, then you can't have a DAPO. So I think there's a long way to go. And I think Andrea's right, they're not quite at the stage to make the use of, the positive requirements in the way that they would like to.
That sort of links to another question that's in the chat, which is, I think I'm right in saying that up to now, the kind of specialist domestic abuse court model in England and Wales hasn't ever had that kind of perpetrator accountability, positive requirement element. The DAPO, I guess, it's a civil order, is trying to fill that gap a bit, but kind of, I guess, why has there never been that? That is the sort of increasingly is the model of practice internationally. So why have we never had that?
I think because when we talk about the criminal justice system as a way of holding people accountable, we sort of look at, let's send them to prison. And for some people, well, for most people, it's sort of the right thing to do. And whether or not it actually is effective in stopping those patterns of behaviour, we're yet to see that. And the hard thing about talking about perpetrators is that there is so much limited funding for victims and their support that I think it's always been quite difficult to say we need to fund perpetrator services. And I think actually what we need to do is reframe that and look at perpetrator programs as a big prevention piece. And I think that that narrative is coming more and more to the forefront due to like amazing charities like Respect, who have been doing a lot of work in this area. And I think that more and more now we're sort of understanding that we can't solve the problem of domestic abuse until we're also talking about how we stop behaviours, stop those behaviours from perpetrators. And how do we do that? Is by investing in good perpetrator services, but also making sure that any services that we do invest in with perpetrator focus have that accountability piece, because people need to know that what they've done is wrong, and understand the whys, and sending, giving them a caution or giving them a suspended sentence isn't going to do that. It's just going to tell them that they can get away with it, and they won't understand what it is they've done wrong.
So for us in the Specialist Court of Westminster, we have more community sentences and suspended sentences with requirements. So we would have probation service led perpetrator programs as part of the specialist court. So, I would say we're probably better at that in our specialist court. The accountability bit, I mean, we've always said we would like that bit. So, okay, your sentence and your probation are dealing with you, but quite often the only response we will see is if someone breaches that order. So what we have always said for a long time, we would quite like to have that, like you get in problem solving courts, then it comes back for a review, like you get in the drug courts. And we would say that element is missing from the specialist courts that we operate.
Well, and just as a reminder to the audience, and I've only just reminded myself, in the original white paper the government put out, I think in 2020, that has launched a new wave of what now called intensive supervision courts, problem-solving courts, for women facing short prison sentences or people at Crown Court facing prison up to 2 years who've got substance misuse issues. Originally, there was a plan of building out from a specialist domestic abuse court that kind of accountability piece, and then it just kind of disappeared as a thing, and it just has never been part of that program. But it's an old axe to grind. I'm going to move on to sort of go back a step, I guess. And Nikki Swardy asked a question about what specific changes do we feel need to take place in how the police treat victims of sexual violence and domestic violence, because that at the moment overwhelmingly negative experience reporting to police means that before they even go to court and press charges, victim survivors are already have negative perceptions of the system. So I guess going back that step, is there anything, Karen, in the coordinated response, or anything you saw, Andrea, in your travels that kind of focused a bit more on that piece?
I mean, we've spent quite a bit of time. So I've been at Standing Together for 13 years, and 9 of those have been co-located with the police to try and improve responses to domestic abuse. And it's DA in the police, community safety teams, public protection, it's high turnover of staff, it's volume crime, and so as new officers, new detectives, you come in. I think it's all down to training. Police need to get their training better. There needs to be an understanding of how to deal with victims of domestic abuse, and it's I just think it's the turnover of staff, the lack of consistent training, the commitment to dealing with victims differently, and also that, I mean, there's a lot of pressure on the police. It like I say, it's high volume, so trying to get they're having to deal with a lot of cases very quickly, and therefore it's their responses. It's more about their resources, and I think when I say it's more about their resources, they're more concerned about how they can get through their cases and charge or whatever than there is actually, are we doing this in the right way?
Yeah, I'd really echo that. And I think in terms of the models that I saw best practice internationally when I was in New York, the NYPD had IDVAs or specialist advocates in every single precinct. So an organisation called Safe Horizon had sort of been pushing from that since the 80s, and having that co-location model meant that there was a much better response. And again, it improves victim engagement, and it also improves case building and how police officers can do that. And that model was also being used in Queensland and Australia. And I think that there's obviously the education piece where you're teaching officers and you're constantly having to teach and reteach about domestic abuse, about how you deal with victims of trauma, about how you respond to them. And sometimes they can just expect, oh, you know, it's a one and done training. But I think from having that co-location model, it's being constantly refreshed, because they have the professionals talking to them about, you know, how you respond to things. They have people who can give them the feedback on, actually, if the way that they responded to a victim wasn't good, they can sort of say, oh, this is how we would deal with it how we would deal with it differently. But also it's that knowledge sharing, that information sharing, and the amount of value in that is huge. So that was probably one of the best aspects that I saw internationally. And I think co-location is such a rare gem here, even though it's shown to be quite effective. And I think that'd be the thing that I would really push forward.
I think it's important that the police have to understand that it is working in partnership. Quite often their idea of working in partnership is they will tell us what they're doing, and then that's it. And it's a partnership between agencies. And also, you know, just the system that the police have of the inspectors and chief inspectors change regularly. And therefore, you know, you start all over again trying to convince someone this is the way they need to be working. For us in AW, which is the area that covers Westminster, Kensington and Chelsea and Hammersmith and Fulham, we are rare. That, you know, we've got a co-located IDVA, you've got a co-located coordinator, and we do a lot of work with the police as part of their training. But as Andrea says, it's rare. There's nowhere else in London that does it, and I doubt there's much in the rest of the country.
Yeah. I'm going to ask one last question, and then we need to wrap up. I'm going to try and sort of merge two questions, which will probably not work. There's one question: is why can't we mainstream innovative courts in this country? So we've got all the evidence, it would appear, and we've got, you know, and it's been practiced. It's not like it's so why can't we mainstream? And then the second question is, which I'm going to try and force into it, is who are the key stakeholders that need to be brought into that mainstreaming? Questions of funding as well. But like, I guess it's a sort of, often in these conversations at the Centre for Justice Innovation, it's about like, how do we pilot a new thing? It's been piloted, it's out there, it exists but like, how do we actually mainstream the thing? So any reflections on that? That might be particularly geared towards Karen, but equally interested if Andrea saw any of that kind of mainstreaming in.
I mean, my view, I don't see why we can't mainstream it. You know, we've had the court it started at Hammersmith, and then I came down to set up the court at Westminster, and so there's been a court around since 2002. We've managed to maintain that. It's clustering cases. You cluster cases into a courtroom, so the court system has to enable those cases to be in there. It does. Everyone in there is doing the job that they're meant to be doing, so it's not unusual. It's just, it's easier for the court to just shove cases around the courthouse to finish it. Whereas if you cluster cases, you know, you have to make sure you keep them in there. Everyone is trained, everyone has read that case, everyone knows what they're doing, all the information's come in. But that's not complicated, so I don't know why it can't be mainstreamed. It is about, you know, when there was the accreditation process for SDACs, it was so much easier because, you know, people wanted to be held accountable and maintain it. And I think the lack of an accreditation process means it's a bit cowboy country, you know. And as I said, you know, there are some areas that say they've got an SDAC, and when I've been and had a look, and I thought, really? And I think, so there's no real reason why we can't mainstream them. Who you need to get on board, obviously the court has to agree to cluster those cases. That's the first start, and then you just get partners engaged. And as I said, there's an appetite out there. You know, when I've been talking to people, there is an appetite. I think people are put off by the word specialist sometimes because it suggests that, oh, specialist court, oh, that's going to cost us. Like I say, it shouldn't cost you anything. If you put a coordinator in, it should cost you, but in the long run, it will save you money. So I think people need to start thinking about actually what's the right way to do it, rather than be put off by the fact that actually, you know, you've got to speculate to accumulate. So it's put the money in, get it working properly, you will save the money in the long run. But the money is tiny in the big scheme of things.
Yeah, absolutely. Andrea, any observations from you?
Yeah, I think the lack of mainstreaming, I think it's the landscape for the court system is just since 2010, to be honest, has been completely decimated. And I think when you have a landscape of so many court closures and a lack of resource, then everyone's really scared to do something new because they're worried that they're just funneling their money in the wrong place. But I think what's difficult is that obviously this has been proven to work, not just here, but internationally. So I think it's more about, now we have a new government who are committed to halving VAWG in a decade. That's how we mainstream, and that's how we say this is how we not only improve the criminal justice system for victims, but this is also how we reduce future domestic abuse, because we're holding perpetrators to account properly and instilling that behaviour change aspect. And yeah, so you have your national stakeholders. We need the MOJ to be involved. We need the Home Secretary to be involved, and sort of those agencies to be working together. But also, you know, within the criminal justice system, the senior presiding judge to be able to actually buy in and talk to the judges and the Magistrates Association as well about the benefits of this. And I think domestic abuse is often just seen as sort of like high volume, but not as much of as, you know, not a huge issue, and should just be dealt with quite quickly, straightforward. But like, you know, like Karen said, these cases are complex, and they need a specialist approach, because the nuances isn't the same as your assault on the street, or your theft from a stranger. And so you have to think about like the fact that, you know, it is a specialist court, but it's not, you know, it's the area is specialist, but the way in which you're dealing with it in the criminal justice system, the structures aren't specialist. Like you said, it's people doing their job, but within a specific structure. So that's how we sort of build that case to them.
Yeah. Well, I think there's potentially hope there. And I think, you know, while I was slightly cynical about the need for new strategies, that may well actually set a direction for a whole parliament that might be quite useful. So we wait to see what that says. And I think you're right, you know, like in some ways some of the hard yards have been done. Of like, we know what the model looks like, we know what the research says. We might need to rebrand, as Karen said, but we're not actually a million miles away from a much better comprehensive response to domestic abuse. I have let this session run over by at least 4 minutes, so apologies for that. I would firstly just want to thank people for attending and spending some of their time with us. Particular thanks, obviously, to Karen and Andrea for, I think, some stunning presentations and observations to questions. Sorry we didn't get through all the questions. That's my fault. But we got through quite a few of them. As I said, in the meantime, please sign up for our upcoming event on women's experiences of attending court, which is going to be on the 22nd of April. We'll send out a link to all of those people, all of you who've attended today, and we'll also send out the link to the YouTube clip of this session. But yeah, my thanks again to all of you for attending. Thanks to our speakers, and I wish you a very good day. So take care. Goodbye.
Thanks very much. Okay.